sessions with people. Okay, I hope you'll find this beneficial, and if any question, please ask during the session. Today we will talk about legal research. Okay, next slide. Okay, before we conduct legal research, okay, I'm sure you have been given tasks to conduct, okay, do research for this, research for that, okay, from different departments, okay. But first, okay, do understand what's the concept and process of that. Okay, next slide. Okay, what's legal research? Basically, it's the process, okay, of retrieving information that is necessary to support a view, okay, or a stand to a legal question. Okay, don't just do for the sake because you are requested to do, you are instructed to do. First, you have this mindset, okay, you are there to retrieve information to support that view. Okay, so the information is not just any information, it must be information that will support your view, okay, or make a stand to the legal question. Next slide. Okay, why do you conduct legal research? Okay, as just now said, in order to have backings, okay, to support the stand. And also, second, which is very important, is that client pays you for your expertise. Okay, so it's not just I think so, I think like this, I think like that. So what makes you think like that? That's where you have your legal research to support that. All right. So basically, you need to provide value for your work. Okay, that's the whole concept of legal research. Next slide. So what is a good legal research? A good legal research consists of the following. Basically, you need to understand the facts in question. Okay, client may tell you the story, okay, from A to Z, what happened. So basically then, from the facts, okay, you get all the facts, okay, ask necessary questions if you need to. And number two, identify what's the question. Okay, it is this question, if you can craft this, what is the question that you need to answer in order to answer client's question or the legal question in your summons, okay, in your proceedings. Okay, if you ask the correct question, then it will help you to dispose the facts are the issue. Okay, so later we will go on this, okay, how to identify the legal question and then get a general idea of the issue from secondary sources, and then identify the law regarding the subject matter, apply then to the facts, okay, then you'll be able to form your view, okay, from the stand, okay, or make a stand or take a view. So convey that outcome of your research, okay, to the person. That's where your opinion comes in. Okay, not necessarily must be in writing, but usually we do in writing to clients, okay, on our submissions. It not necessarily must be written. It can be briefing your superior, okay, the outcome, what you think from the research there. Because as I said earlier, it is to support your backings, your views. Okay, right. Next slide. General principles, okay, just to go through. So yeah, next slide. So always start your research from secondary sources. So why do we need to start from secondary sources? Is to obtain a general idea, okay, of the subject matter. So lawyers must have a basic knowledge of the subject matter. So that's where you search from your secondary sources. So examples of secondary sources here are articles, textbooks. We always Google, right? Okay, and then what write-up are, what sources are there. So usually Google will provide a very good secondary sources, okay, of law, encyclopedia, journals, okay, or that will provide you at least a general idea of what is that. Okay, so basically you get a broader, okay, it is a very broad, okay, sense, okay, context, give you a context, okay, and from there you'll be able to find what is the primary law that I need to find from the secondary sources, okay, because like let's say article, you have the endnotes, the footnotes, okay, where is that source from, which textbook or which case law. So then there you'll be able to find that, okay, your primary source. And when reading your secondary sources, you note the cases that related to your set of facts. It may not be 100% the same, okay, identical facts, but the issues may be similar. The facts may not that similar, okay, may not 100% similar, but the issues, okay, the facts, the issues will be quite similar. Okay, you'll find similar issues, but although different facts. So then you follow up on those cases, check the head notes, and then read the decisions. Okay, always, okay, when you go through the decisions, don't forget to go through the decisions. From the cases referred, then you see other cases referred to that cases, right? Then you will end up have a string of cases, okay, on that issue alone, where you can read and decide if they are relevant to your facts. So that's how we do our legal research. Next slide. And then you need to confirm your authorities are still good law. The authorities can be the acts, the statutes, even the cases. Are they still good? Are they still valid? Okay, or they have been overruled. All right. So you can actually check this out in the Lexis. Okay, we have the function where the case analysis, okay, it's been neutral, okay, still referred to but not repealed, or affirm, okay, or reverse. Law also, I mean, for acts, then I will usually go to the CLJ, and then that particular acts, you see all those amendments have been made. So if there are amendments, I mean, a later version, you see a later version there, then that one may not be a good law already. Okay, so you need to see the latest one. Okay, so CLJ will have that. Okay, all sorts of all the amendments under that particular statute. So you will see whether you are referring to the still good law or not. Okay, so please remember, never cite authorities in your submissions if you are doing civil proceedings. Okay, citing an outdated authorities or authorities that have been repealed to the court, it can land up, okay, in contempt of court. Yeah? So make sure that your authorities are good law, are still applicable, are not being repealed. Okay, and keep a record of the sources. When I did civil procedure, I mean civil cases back then, I'd have a notebook of myself. Okay, I record of the sources and the cases, because when I write that, I remember. Okay, I used to do a lot of summary judgment, and then those cases are principle for summary judgment where you establish prima facie cases. You already know at hand what are the cases, all right? So if there's update, then I record that. What are the updated cases on that area? Okay, so the purpose is that it will make your work easier. Once you already have that compilation, okay, you know where to find it. Okay, immediately at court already, like open court, straight away you can cite those cases before the court. Okay, so making notes also important, keeping a records. So you need to so that you know where to find them if the same subject matter arises in the future. Because if you do like civil procedure, summary judgment, you get the same, more or less the same issues, the same defense will be raised by the other side. Okay, so we know where to find the authorities. Next slide. So identify legal question. Okay, this is the very crucial part, not the facts, not the law, but this is, okay, the correct legal question, if you crafted the correct legal question, then you get the correct legal answer. If this correct legal question is not correct, then your whole case can rosak. Okay, can koyak. Okay, next slide. Okay, where you are being presented with facts or information, you need to determine what is the legal question. Client may give you, okay, client will stop. They will just stop. They don't know what is important or not relevant. What is you who are listening to the client's facts, okay, you will decide whether it's relevant or not. You will sift there, you will be sifting the facts. All right. Okay. So then from there, from the facts given, what is the question that you need to ask yourself? Okay, that will help you to find the answer to the issue. So identifying the issues correctly will help you determine the areas. Then you will know which area I should look to. Okay, that you need to conduct your research. Right. Right now, can any of the pupils here share how do you do your legal research, or how the assigner, the people who assign you tasks, how they assign you the task for research? Can I hear from any of you here? Aini?
Hi, Miss Boyi. Okay. So
did they give you the facts? Whoever lah, Mr. Tu, or even from corporate department or whoever did they give like the facts and what's the legal issues?
Okay, there are a few lawyers who would give me the facts, but there are lawyers who they don't provide me the facts. They just straight away went to the question that they want, and they want the legal cases to support the stance that they want to look for. Usually I get that kind of task.
Okay. Okay, not very complete. Okay. Legal question will not form by them. Okay. This is for purpose when I'm presenting this information is when you single-handedly handle the facts. Okay. Of course, people may be different lah. You can get to handle the case from A to Z. Okay. So your whoever, your master or your who will just give please find this, please find that. But this one is from A to Z. Okay. I'm explaining to you how I did from my previous experience when you single-handedly handle the matter. So you need to get the facts. We'll be dealing with clients, right? Next time when you're practicing, that's where you get the facts. Okay, you need to understand the context, because the facts will give you the context, okay, of where you can form the legal question correctly. Okay, Ken? All right, we continue. Next slide. Okay, let's come to this scenario to help you understand the points that I said just now. Okay, this one is one of the scenario. It's a real case that I handled, okay, in my previous firm. Employment issue. Okay, so how we advise our client based after the legal research. So your client, okay, BAC Senjam Berhad business activities. Okay, all these name and dates have been changed been affected in recent years. Okay, particularly since April 2020, we know that MCO have hit the country, right? Then resulting in losses of approximately 2 million RM. So on grounds of business efficacy and to curb increasing financial losses, so this BAC, they want to exercise its rights to reorganize or want to restructure its business. Right? The reorganization or restructuring will have to involve a discharge of surplus labor. They have to do away with, okay, they have to reduce their labor. So that will result in a redundancy of 65 employees. Okay? These are the facts that they told us. So this company, BAC, is of the view that this could be done, okay, by 30th November 2021. And the company intends to achieve this in a manner that is amicable, okay, to the employees, okay, and incurs the company no further liability by way of unlawful dismissal claims. So they want it fast. They want it by 30th November, fast and no liability. These are the two. Okay? Sometimes you have to ask, okay, from these facts, what do you want? You have to ask client, what do you want? Right? These client tells what they want. Okay, not just take facts, then you don't know what they want. Then you don't know how to do your research. Okay? Yes. Next slide. Zato, next slide. Okay, so what is the legal question, okay, from the facts just now? Okay, whether BAC Sdn Bhd would be able to retrench the surplus worker, 65 workers, by 31st November 2021 without incurring liability by way of unfair dismissal claim. Because unfair dismissal claim, if they lose, BAC have to pay, right? You have to pay back wages. All right, so this is the question. This is the question. All right, go ask yourself other questions. Okay, these are the questions. So from here, how do you start your legal research? What do you need to know? To answer yes or no, would they be able there? What do you need to know? Anyone want to try before I go to the next slide? What do you think that you should start your legal research with? To answer this question. I want to try? Oh, okay. Don't you think that the most important thing you would want to know is what is the law on retrenchment, right? What is retrenchment? Okay, for you to understand, for you to be able to reply client on this issue. Okay, so next slide is, Azato, next slide. Okay, what is the law on retrenchment? So that's where your research starts. What is retrenchment? Okay, is the discharge of surplus labor. Basically, is the discharge of surplus labor. It can be for any reason. Okay, so basically, retrenchment in Malaysia is valid. Okay, it's a valid ground. Court would accept that retrenchment. Okay, provided that it is done in good faith and you follow the procedure. Okay, there are procedure to retrench, not just today decide, then tomorrow kick, cannot. Okay, there are procedure. So these two, okay, good faith and you follow procedure, okay, court won't interfere. Okay, so employer has a right, because this, why it is a valid ground, because court also recognize employer, okay, has the right to determine the number of the employees it needs. Okay, no law cannot say that you can never terminate an employee. No law has ever said that. Okay, so in this regard, the industrial court usually adopt a non-interference. Okay, this is what we write up from the research. This where you can find this. You can find from the textbook. Okay, a law on retrenchment. There's our library also have. There's one on Maimuna something. Okay, a white color book, a hardcover book. Okay, it explains very good explanation on retrenchment. So that's why I extract the law on this. Okay, of course from other sources as well. All right, next slide. So there is also this code of conduct, very important. When you're doing retrenchment, you need to refer to this code. Okay, we call that a Code of Conduct for Industrial Harmony 1975. It provides what are the guidelines. Okay, this code also talk about other practices, but there's one chapter on retrenchment. Okay, very useful. So we note down. Okay, we want to retrench. The code says that your employees to take to take positive step to minimize the reduction. Meaning, retrenchment cannot be the first resort. It can only be the last resort. Okay, you need to take positive step first to minimize the reduction of workforce. Example will be you freeze, okay, on new worker. You no more recruit any new workers. That's one of the measure. Overtime, no more overtime. Okay, you reduce maybe hours of work. Okay, for some of the sectors. These are some of the positive steps. So the industrial court generally will scrutinize, okay, based on the facts. Okay, if this case go to court based on the facts that the company did they do this, okay, they will refer to this code. Okay, of course, this code is not a law, it's not a statute. So it's called, this code, you give a guideline, it's like best practice. You follow, the court will make sure you follow. Okay, this retrenchment exercise, okay, whether it's properly made or not. Okay, they will see, compare with the code there, refer to the code. Okay, so next slide. So if retrenchment becomes unavoidable, let's say after you have taken all the positive steps, if it's still unavoidable, then employer ought to do the following things. Okay, you have to give warning early to the affected workers, and then to introduce a scheme of voluntary retrenchment. Okay, called a DSS, or redundancy benefits. Okay, some payment or some kind of compensation. Retire workers who are beyond normal retiring age, or you assist workers to find work elsewhere, or you spread the termination. Okay, sorry, these are not all, these are all N. Spread the termination of employment over a long period. That means you don't one shot kick out all the 65. Okay, you have to spread 2-3 months, 20 or 10 until 60 for 6 months. Okay, but it cannot be one shot. Okay, next slide. Okay, so in the selection of employees to the retrenchment, to be retrenched, okay, there is this rule, we call it last in, first out. The one who come in last will be the first out. Okay, we call it LIFO rules. General principle, you must comply with LIFO rules unless you have a good reason not to follow. Okay, and take note also of Employment Act. Okay, where some of the sectors they have the employees who are under this act. Okay, who are subjected to this act. Okay, section 60N. Okay, it provides. You want to retrench, you have to first retrench foreign workers before you retrench Malaysian employees. Okay, provided they are carrying similar work, same work. Then 1660M. Okay, prohibits employer from retrenching a Malaysian worker for purpose of hiring a foreign worker, also cannot. All these are very important in take note. Okay, so and recognize exceptions to the LIFO will be competency, maybe poor performance. So you cannot follow, you strictly follow the LIFO rules. All right. Okay, next slide. And then notice of retrenchment, you must give adequate notice. Okay, of course, per the contracts lah. If the contract say 2 months and 2 months, 3 months and 3 months. If the contract doesn't say, then you fall back to the Employment Act. And then employee should be informed of the impending retrenchment as soon as possible. Once the company made the decision, inform the employee, the affected employee. Okay, and failure to consult or warn the employee may cause the termination to be considered as bad faith. Okay, maybe one of the reasons for unfair dismissal. Next slide. And then Employment Act Section 12 is the length of the notice. Okay, how long is the notice that you should give? If it's not covered under the contract, okay, you fall back into an Employment Act. These are the periods of notice. Okay, if you are 2 years less, 2 years and less, I mean less than 2 years, 4 weeks notice means about 1 month. So it's between 1 month to 2 months. Okay, 4 weeks to 8 weeks. All right, depending on the number of years being employed. Okay, of course, this can always be waived by the employee himself. In absence of that, you have to follow. Okay, so that's what the law says. And then next slide. So, okay, that's the period part. This one is the compensation part. Okay, is there any obligation to say that employer must provide compensation? Actually, no, none. Industrial Court Act also doesn't say must. Industrial Relations Act doesn't say that we must give compensation, but the court will say in cases that say that it is advisable, okay, for employer to grant compensation, or we call that termination benefits, okay, to achieve the impact of retrenchment, to make your retrenchment successful, okay, offer that compensation. So it's usually offered on the basis of provisions, okay, in the employment contract, or will be regulated under this employment termination and layoff benefits. Okay, so of course there are alternatives, okay, to retrenchment, and then retrenchment exercise, okay, is not, however, without its detriment, because an employee can still be liable for unlawful dismissal, okay, and will incur losses. I mean, they incur liabilities, okay, in terms of compensation they have to pay to the employee. Okay, so with the above in mind, there are a number of alternatives available for the company, with the most common being a VSS. Okay, there's one alternative to retrenchment. Okay, next slide. So what is a VSS? It's a scheme which operates on the basis that the employees are invited to participate in a retrenchment plan on a voluntary basis. It cannot be forced. Okay, so in consideration of opting for this, to be out, okay, to leave the company, so there will be an attractive severance package, which will include benefits, okay, accrued benefits, or ex gratia payment. So advantage of VSS is a quite number, okay, because if you choose a VSS, you don't need to follow LIFO, okay, because it's given absolute freedom. Okay, you can choose, okay, or any one of the employee who offer for VSS, the company can choose whether they want to accept. Okay, and it's more flexible. VSS is more flexible than retrenchment. So, and another thing is to reduce, it will reduce talent drains, because if it depends on who will offer himself for the VSS. If, let's say, this employee A, okay, offers himself for VSS, and it's up to this company whether they want to accept this offer. All right. If they say they still need this employee, they may not accept that offer for VSS. Okay. So it can, this way it can also reduce the talent drain, and also, of course, reduce the risk of unlawful dismissal. Chances of, if you already offer a sum of compensation, the chances of the employee bringing a claim for unlawful dismissal will be much lower, right? Yeah, because this one is on the basis that it voluntarily offer himself. It's not forced, right? So if later you want to bring claim for unlawful dismissal, the chances for the employee is lower because he voluntarily go and offer himself, right? Okay, next slide. So VSS needs to be carefully planned, and the following are some areas of consideration that should be taken into account by the company. Okay, the number of employees who they should have control. So also they say, although it's like offer, okay, to the employees, they also must control a number of employees, okay, who are allowed to take that advantage will be controlled by management. And then for a period, how long? Okay, it cannot be forever. So it must be within that period. Okay, before they want to clear off all the employees, they will fix that period, 1 month, 2 weeks, okay, 3 weeks. So and potential discrimination, okay, for either directly or indirectly, okay, in determining which employee should be eligible to be must be avoided. They cannot discriminate, okay. That means this category of employee cannot participate in this VSS. That's discrimination. Okay, so they cannot discriminate. Must be employee, then must be open to all employees. Business needs of the organization, okay, must not be compromised. Okay, all right, next slide. So of course, other than VSS, these are other alternatives, okay, if the company considering, okay, VSS, if they want to adopt any of these other alternatives, okay, temporary layoff, a sabbatical leave, usually sabbatical leave will be no leave, no pay leave. Secondment, okay, if they have got subsidiary, they will second them to the subsidiary if the subsidiary needed. Okay, redeployment, change the department, change to other department. Early retirement, okay, shorter working week, okay, or flexible working system. So these are some of the alternatives. Next slide. So VSS would be functional only if it offers a general package. Okay, you want to attract, of course, it has to be a generous package. So the financial aspect of the VSS to the company, then it's up to the company. They have to make their calculation. Okay, will it outweigh? Okay, outweigh later if they have to pay dismissal claim, unfair dismissal claim from the employee, or is it this one more worth it? All right. So it's up to the company whether they want to offer this. Under a retrenchment exercise, particularly for long-serving, okay, or highly paid employees. All right, when considering a VSS exercise, then the employee must comply with any requirement. The employee also have to procedure to comply. They must lodge the PK form, okay, with the Labour Department 1 month before any retrenchment date. And you must note that employee can no means be forced to accept a VSS. It's very important, yeah. Okay, it must be on voluntary basis. Okay, next slide. This one, next slide. Okay, so with all the information, okay, the research is now that we have done on what is the law on retrenchment and the alternative to retrenchment. You already got somewhat form of view already, right, to the legal question just now. Okay, client want to retrench these 65 workers by 31st November. Is it possible? Is it possible? Based on the law just now I explained? Not right? Not right? Because like now October, okay, 30th November, some with like 5 years plus, okay, the 65 workers are, let's say some of them 5 years plus, you need 8 weeks. You need 2 months notice. Okay, so 31st November is not a possible date. Okay, so based on the research that you have done, so based on that, then we advise the client, it's not possible okay, you may want to consider deferring the date. Okay, so but you must give an alternative. What's the better date? Okay, what's the more reasonable date? Actually, an additional 2 months will be necessary. Okay, maybe by December or January, you can. Okay, January 2022, that would be better. Okay, if they are okay. But we have to give reason, justify based on the research that you have made. Okay, 31st November is not possible because it's less than 2 months. Okay. So additional 2 months will be okay, okay, to avoid any potential claims. And also at the same time, we advise that, okay, you may consider, because client want two things, right? When they want fast and they want without incurring unfair dismissal claim, okay, if they lose. So we ask them to consider VSS. Next slide. Okay, you can, this is what you advise client, okay, can be initiated as soon as possible upon a decision of the company. Okay, of course, whether to undertake a VSS or not, the company needs to have, it will meet, okay, you have that high level, their board of directors to decide. Okay, of course, they have to decide, come up with a solution that they want this VSS, then only they can start doing the VSS. Okay, of course, the money, how much you will involve, okay, how much cost, this one, all, okay, this one will up to the company to deliberate. Okay, this is a much of a commercial decision already lah. But they need to consider, you want to pay VSS or want to pay compensation in unfair dismissal claim, up to them. Both also they have to pay, right? So which one will outweigh, which benefits will outweigh which, okay, which is more beneficial to them lah. Right. So of course, when we give legal research and the opinion, the final decision is always up to the company, the client. But we have these backings, okay, backings from the research that we have made in order to make that stand, to form that view. Okay, this is what we form now. The company should take a VSS to avoid possible claims. Okay, and of course, when they want to consider this VSS, these are the things that the company will want to consider: the value, how much you want to offer, what's the total sum, what's the impact of the company. Okay, that one they have to check with their accounts or their finance. Okay, and then company awareness, okay, of the financial difficulties by the employees. Whether the employee understand, are aware of the financial difficulties or not. That's also very important. So that's why the company needs to inform, okay, the employees of impending retrenchment as early as possible. Get the employees to understand the company's financial difficulties and the time required to comply and the time required to issue VSS notice. You still have to issue a notice of VSS, right? All right. So they may want to reply. Okay, issue notice to these employees. The employees may want to reply. Okay, then give them a period to reply. Right, and then next slide. Okay, should also VSS offer should also stipulate a reasonable time period for acceptance or rejection. Okay, as I said just now, cannot be forever. It should plus a time period. Okay, accept or reject, and then a rejection can be followed by with a retrenchment. So company's board of directors ought to be appraised, okay, of all these above factors, and a VSS will incur additional costs to the company, okay, owing to the ex gratia payment, because it will involve ex gratia payment and will exceed the amount projected by the company in the list provided to us, okay, on the last meeting date. This one because when we meet client that time, they give us a list. Okay, then the VSS would should reduce the risk of the company for claims for unlawful dismissal. Okay, if that given that the VSS is dependent, it must also be accepted by the employee. Okay, so these are the opinion that we give to client based on the research. Okay, I think that's all. Is there any question? Any feedback? No? Okay, I hope you find it useful. If any question when you're doing research, okay, feel free to ask me, or which area that you need help, okay, on legal research. I'll try my best to help, all right? So thank you for attending. If you want these notes, I can always get from Maisato, okay, but we will also save it in the library, okay, library's folder. All right, thank you.